Mr. Murali Pillai.
Sir, it is the parents' responsibility to bring up their children well so that they have the best chance possible to succeed in life. By and large, it would be a natural instinct on the part of the parents to discharge this duty. Unfortunately, from time to time, there have been cases of parents abdicating their responsibility towards their children. Just on 2nd March 2018, during the COS debate on the Ministry of Home Affairs, we heard the Honourable Minister for Home Affairs providing some examples of serious child abuse and neglect. These are heart-wrenching cases. The principal legal tool used to intervene when a child or young person is neglected by his or her parent is the Children and Young Persons Act. Under the Act, a child or young person is deemed to be in need of care or protection if his or her situation falls within the 9 enumerated categories stated therein. In such an event, the Director of Social Welfare, a protector, or a police officer is empowered to remove the child from the custody of the parent and place him or her in the place of care and protection. I recently had occasion to deal with a case which threw into focus the current requirements under the Act. Sometime in the second half of last year, I met the parents of a 7-year-old boy. The boy's father sought my help to deal with a problem he had with a police officer. The mother was a young lady who was rather quiet. While I was talking to the father, I noted that the boy sported long hair. It was even below his shoulders. Curious as to how he could keep such long hair in school, I asked the boy which school he was studying in. To my surprise, I learned that he was not registered in a primary school. This is a violation of the Compulsory Education Act. As a matter of fact, the boy did not go to kindergarten as well. Both parents were content for their son to be at home and schooled by his mother. However, prior approval from the Director General of Education, as required under the Compulsory Education Act, was not sought. I must add that from a physical perspective, the boy appears to be reasonably well taken care of. Mentally, he's normal too. My community leaders engaged the father and attempted to persuade him to register his son for school as soon as possible. Based on the last update I received, despite 6 months of trying, the boy has yet to be registered. He's 8 years old now this year. Officers from MOE and MSF have been engaging the father and trying to persuade him to send his son to school. Under the Act, as the boy is physically well taken care of, it would not be possible to intervene under the Act on the ground that the parent neglected to ensure that he is enrolled in a primary school. In response to a parliamentary question I filed in November 2017, suggesting that the criteria under the Act be expanded to include situations whereby a parent neglects sending a child to primary school, the Honourable Minister replied that the reasons for a child not attending school are often complex. The Honourable Minister opined that it was not necessary to extend the criteria under the Act on the basis that the framework provided under the Compulsory Education Act already covers this aspect. Finally, he explained that the Act is meant to be invoked where children are seriously harmed or at risk of serious harm. I respectfully seek a reconsideration of the government's position for the following reasons. First, I think we can all agree that it's critical for a child to attend primary school for the sake of his own development and to create that common experience necessary for the child to identify himself as part of our community and nation. This is the raison d'etre behind the enactment of the Compulsory Education Act in the first place. Second, the framework under the Compulsory Education Act does not extend to intervening in the event a parent neglects sending his or her child to primary school. What it does is provide penal consequences. However, it does not directly address the plight of the child if the parent does not do the right thing. Also, as mentioned by the Honourable Minister for Education Schools, Mr. Ng Chee Meng, in this House before, the approach of MOE is not to charge the parents in court, but to counsel them to comply with the requirements. Third, the future prospects of the child would be indelibly affected by reason of the parents' neglect in registering him for school and ensuring that he attends school regularly. While this is not physical harm, it is harm that is still debilitating in terms of the impact on his future. In my respectful view, the Compulsory Education Act and the Children and Young Persons Act should complement each other so that the whole suite of options would be available to help the child if a parent neglects to send his or her child to school. After all, the parent would have committed a criminal offense by virtue of his conduct. I'm aware that we are not dealing with big numbers. In 2003, this House was informed that there were about 10 cases of violations under the Compulsory Education Act per year. In my respectful view, though, even one case of a child being deprived of education is a case too many. I'm not advocating that the powers be exercised in every instance a parent does not send his or her child to school. I acknowledge that the reasons are complex. All I'm asking is that the state be provided with the requisite powers so it can intervene in an appropriate case.
Thank you.